Welcome, and thank you for joining us for today's discussion on strengthening national security and privacy in the digital era with the Privacy Commissioner of Canada, Danielle Therrien. My name is Aaron Shull, and I'm the Managing Director and General Counsel at CIGI, the Centre for International Governance Innovation, and it's a pleasure to have you with us. National security is important, not just for government, but for all Canadians. It protects our physical security, our prosperity, and indeed, our values. However, the world is at an inflection point. We're experiencing tremendous political and economic shifts and a combination of new and enduring threats, whether from state or non-state actors or from global phenomena like pandemics and climate change. Emerging security challenges are greater than ever and are directly impacting our economy, our democratic institutions, and our way of life. This is the fourth in CIGI's National Security Speaker Series. To date, it has featured some of Canada's most prominent senior government officials from security and intelligence community throughout Ottawa. This has included the Director of the Canadian Security Intelligence Service, David Vigneault, Shelley Bruce, Chief of the Communications Security Establishment, and Vincent Rigby, National Security and Intelligence Advisor to the Prime Minister. It is in this context that I'm delighted to introduce our speaker, Danielle Therrien. The Privacy Commissioner of Canada is an independent agent of Parliament who represents Parliament rather than a minister, and whose mission is to protect and promote privacy and to enforce the Privacy Act, which applies to federal government institutions and as well as Canada's federal private sector privacy law. Danielle Therrien was appointed Privacy Commissioner of Canada on June 5, 2014, after 3 decades of serving Canadians as a lawyer in various federal departments where human rights issues were important. He was reappointed by the Prime Minister for a 1-year term in June 2021. Commissioner Therrien spent most of his career at the Department of Justice, including almost 10 years as Assistant Deputy Attorney General, where he had a leadership role in providing legal advice to government on public safety and national security issues. He was instrumental in negotiating the adoption of privacy principles governing the sharing of information between Canada and the United States under the Beyond Borders Accord. In his current role, Commissioner Therrien has led several investigations with important implications for the privacy rights of Canadians, including the 2019 Facebook Cambridge Analytica scandal, the Equifax global data breach, as well as the 2020 investigation into Desjardins, the largest ever data breach in Canada's financial sector. We are so pleased to have Danielle join this important forum for a sophisticated dialogue on the intersection between privacy and national security. As a procedural matter, the event will be recorded and posted at cgionline.org for future viewing and sharing. And please note that there is a Q&A function, and we actually do want you to use it at the bottom of your screen. Please feel free to ask questions at any point during the conversation, and we'll do our best to get to as many questions as we possibly can. Thank you for joining us, and thank you so much, Danielle, for being here today as a speaker. Over to you, sir.
Thank you very much, Aaron. Thank you for the introduction, and thank you for the invitation to speak today at this CIGI event. CIGI founder Jim Balsillie has become an important thought leader in the debate around privacy and security for the innovation sector and beyond. He and I agree on many things related to privacy. For instance, I agree with his observation that data governance is the most important public policy issue of our time. One can hardly dispute that data is becoming increasingly important in the economy and that we're witnessing the rapid development of data-driven technologies. Where the first industrial revolution was powered by steam, the fourth is driven by data. More and more companies are seeking to monetize our personal data, while governments are looking at various initiatives to promote data-driven decision-making, greater data sharing, and making data more accessible. Technology and data can, and do in many cases, serve the public good. The pandemic offers many examples of that. The use of data to support public health, or the platforms we have all been using to stay connected. But the growing importance of data also comes with potentially serious new risks to our privacy. We must urgently consider how to derive benefit from data while respecting our democratic values and fundamental rights. This afternoon, I would like to address two related themes with you. The first is the need to balance emergency measures with privacy protection. The second is the need to embed Canadian rights and values into updated privacy legislation in order to protect individuals, give government the tools it needs to carry out its work, and promote responsible business innovation. No matter what role brought you here today, whether your interest is in business, government, or policy, the issue of protecting personal information is one that should matter to all of us. In fact, if there's one idea you need to leave with today, it is that privacy protection does not stifle economic innovation, nor does it stand in the way of Canada's national security interests. Indeed, good privacy laws can support both. A little bit of history. The privacy landscape has changed dramatically since I was appointed to this position 7 years ago. In 2014, tech executives openly talked about privacy being dead. Following 9/11, the need to protect against further terrorist attacks was seen to outweigh personal privacy interests, which led to laws that went too far. At least some laws went too far. That view, that privacy should cede the way to other interests, started to change with the Snowden revelations. In 2021, it is clear that privacy is very much a live issue. Indeed, our polling shows it preoccupies the vast majority of Canadians who are very concerned about their inability to protect it, namely from the growing power of companies like Facebook and Google, which seem to know more about us than we know about ourselves. No one has monetized personal data better than the tech giants behind our web searches and social media accounts. But personal information is also the lifeblood of national security and intelligence agencies. The collection, use, and disclosure of personal information has always been integral to their work. Our interest at the Office of the Privacy Commissioner is to ensure that while such agencies have the tools they need for their critical work, they use them in a manner that complies with the law and respects privacy rights. As we saw after 9/11, when faced with a security crisis, decision makers tend to take strong actions without necessarily giving rights due consideration. It bears noting that crises are not confined to terrorism. The 9/11 terror attacks took the lives of nearly 3,000 people. The current pandemic has claimed more than 4.8 million lives worldwide, nearly 7,500 per day. This too, obviously, is a threat to public safety that has resulted in exceptional measures. When the COVID-19 pandemic emerged, some felt privacy should be set aside in order to protect lives, just as happened after 9/11. This was based on the false assumption that we either protect public health or protect privacy, that we cannot do both. I disagree. Privacy and innovation brought about by new technology are not conflicting values. This is not a zero-sum game. In fact, trust in innovation depends on the protection of rights. Without privacy, there is no trust, and there is no sustainable innovation. While my office has recognized that the health crisis calls for a flexible and contextual application of privacy laws, because privacy is a fundamental right, key principles must continue to operate, even if some of the more detailed procedural requirements are not applied as strictly as in normal times. Last spring, my office, along with our provincial and territorial counterparts, issued a joint statement calling on governments to adhere to several key privacy principles as they developed vaccine passports. Above all, we stressed the need to establish the necessity, effectiveness, and proportionality of vaccine passports. More specifically, we said that vaccine passports must be necessary to achieve their intended public health purpose, that they must be effective, and that the privacy risks associated must be proportionate to the purposes they are intended to address. Vaccine passports are only one of many issues for the protection of personal information arising during the pandemic. Contact tracing applications, temperature checks, and vaccine mandates have all raised important questions. All of these require the application of key principles. Notably, they must be shown to be necessary, effective, and proportional. Many of these measures have been shown to be necessary during the pandemic, but I'll say the jury is still out as to whether they were effective and proportional, at least some of them. The jury is still out as to whether they were effective and proportional. Meanwhile, for much of the pandemic, daily life has unfolded online. Socializing, going to school, and seeing the doctor took place through online platforms, raising new risks for our privacy. For example, telemedicine creates risks to the doctor-patient confidentiality when virtual platforms involve commercial enterprises. As the pandemic speeds up digitization, it has served to highlight long-standing significant gaps in Canada's legislative framework. For instance, the law has not properly contemplated privacy protection in the context of public-private partnerships, nor does it mandate app developers to consider privacy by design. It is troubling to watch the pandemic drive rapid societal and economic transformation in a context where our laws fail to provide effective protection for Canadians' privacy rights. Why is it troubling? Because privacy is more than a best practice that can be set aside for what are perceived to be higher public interests. It is a fundamental right and an important societal value. Its contours may change during an emergency situation like a pandemic, but the fundamental principles and the fundamental importance of privacy remains, even in emergency situations like a pandemic or like 9/11. For all the talk about the fourth industrial revolution, technological advances and vulnerabilities surrounding the collection and use of personal information, I must emphasize that technology itself is neither good or bad. New technologies can, of course, bring great benefits, but there are also risks. One of the primary purposes of regulation is to create an environment where individuals feel confident that their rights will be respected. Unfortunately, the failure to ensure our laws keep up with the times has led to a crisis of trust in Canada, particularly when it comes to online activities. Polling tells us that Canadians are very concerned about their privacy. A scan of the headlines on just about any day of the week explains why. This month, as Aaron alluded to, a whistleblower accused Facebook of prioritizing profits over fixing algorithms that spread hate and misinformation. A few years ago, the Facebook Cambridge Analytica scandal revealed the potential impact of online platforms on privacy and the integrity of elections. Meanwhile, ever bigger data breaches have become regular events. We see breaches affecting millions, indeed hundreds of millions of people. My office investigated the Desjardins breach that compromised the personal information of almost 10 million Canadians, among other breaches. Other recent investigations by my office, meanwhile, have raised the specter of mass surveillance in Canada. I'm referring here to our related investigations into technology company Clearview AI and the RCMP. Clearview scraped billions of images of people from across the internet and then allowed law enforcement to match photos against the company's massive data bank, which was 3 billion images at the time and is apparently now 10 billion images. We found this collection of highly sensitive biometric information, without the knowledge or consent of individuals to be illegal, putting millions of people, the vast majority of whom will never be implicated in a crime, into a 24/7 police lineup is clearly unacceptable. Our investigation into the RCMP found the police agency's use of facial recognition technology to conduct hundreds of searches of a database compiled illegally by Clearview to be a violation of the Privacy Act, the public sector law. Our investigation also revealed serious and systemic gaps in the RCMP's policies and systems to track, identify, assess, and control novel collections of personal information through new technologies. As a result of our investigation, the RCMP is establishing now a National Technologies Onboarding Program, NTOP, which will serve to identify and assess the legal and privacy implications of new investigative technologies. This is obviously an encouraging step, one that I hope will lead to change. Ultimately, however, real progress in building trust in the digital environment will only come when we adopt robust privacy laws. Canadians want to enjoy the benefits of digital technologies. It is the role of government and Parliament to give them the assurance that legislation will protect their rights. Strong privacy laws build trust in our systems and institutions. They also build resilience in the face of security threats. Some may see privacy protections as simply a constraint on our activities, but from another perspective, they are an active defense. Not having effective privacy laws creates vulnerability, what the military would call targets of opportunity. You may have read about a breach of athletes' information at the World Anti-Doping Agency, or WADA, a few years ago. The incident involved the disclosure of information about certain athletes who had competed in the 2016 Rio Olympic Games. Subsequently, Canada and its allies attributed the hack to Russian military intelligence. At the time of the breach, Montreal-based WADA had certain safeguards in place, but an investigation by my office found they fell well below the level expected of an organization responsible for protecting highly sensitive medical information. WADA's status as a potential high-value target for sophisticated state-sponsored hackers also demanded an adequately robust safeguards framework to protect medical information, but beyond that, to protect reputation. Threats can come from anywhere: security and intelligence services of hostile states, ransomware hackers, organized crime syndicates, or other disruptors. They will target government installations, major oil companies, even hotels and dating websites. It doesn't take sophisticated adversaries long to link data chains together to gather enough sensitive information to cause harm. I alluded earlier to the fact that laws passed in the wake of 9/11 allowed a greater incursion into privacy. Bill C-51, the Anti-Terrorism Act of 2015, was one example of an anti-terrorism measure that caused concerns because it went too far. Bill C-59, passed in 2019, rolled back some of C-51's excesses after healthy democratic discussions in which my office played a part. It also created oversight bodies, the National Security and Intelligence Review Agency, or NZIRA, and the Office of the Intelligence Commissioner. Bill C-22, meanwhile, introduced the National Security and Intelligence Committee of Parliamentarians, NCCOP. My office's expertise is complementary to that of those oversight bodies. While they are experts in national security law, we are experts in privacy law. The combination of our respective expertise, we think, adds value and depth to the reviews we undertake together. We regularly engage with NZIRA, for example, under an MOU whose terms and goals were finalized and made public a few weeks ago, because we want to be transparent with the public and national security agencies on the terms of our collaboration. We have also recently seen a welcome rise in requests for consultations on national security and public safety issues, consultations by departments and national security agencies. We continue to advise the government on these matters, for example, in relation to the Passenger Protect program. Still, concerns will continue to arise. For example, encryption. It's a policy area that cuts across traditional conceptions of privacy and national security. It directly affects commercial and governmental sectors and their day-to-day operations. Some say that better encryption tools provide individuals more protection, while others argue encrypted communications make us less safe because they embolden criminals, cost more, and unnecessarily complicate or slow down analysis. Law enforcement and national security agencies have shown they would sometimes like to find ways around it. We know basic encryption would have greatly benefited the privacy of those affected by the numerous data breaches my office has investigated over the years. And from the standpoint of classic information security, anyone who has worked a day in a classified environment will be very familiar with the added safeguards that encryption provides for protected information. The widely publicized battle between Apple and the FBI a few years ago over investigators' access to the locked cell phone of a mass shooter in California brought difficult issues of privacy, governmental access to data, and encryption to the forefront. After considerable legal maneuvering, in the end, the FBI abandoned its attempts in court to compel Apple to alter the security features on its systems and products. Investigators with the FBI instead contracted with a separate software firm to circumvent the phone's protections. Unfortunately, what that instance demonstrates fairly clearly is that there is no known way to give systemic access to law enforcement without simultaneously creating an important risk for the population at large. We have recommended that Parliament proceed cautiously before attempting to legislate solutions. In our view, it would be preferable to explore technical solutions which might support discrete, lawfully authorized access to specific encrypted devices, as the FBI successfully did in the San Bernardino case, as opposed to imposing general legislative requirements. All this to say, before legislators hasten to legislate limits on proven data protection safeguards such as encryption, I believe we need an open discussion of where the specific problems are and what measures already exist within the current law. Canada has just elected a new parliament. Among the central tasks for legislators returning to Ottawa will be to adopt modern, effective laws that enable responsible innovation and economic growth while protecting the rights and values of Canadians. We need a rights-based framework that recognizes the fundamental right to privacy. Last year, we saw some movement on both the public and private sector fronts legislatively. The federal government circulated a consultation paper proposing updates for the Privacy Act, our public sector law. My office is optimistic about the direction this consultation and this policy is taking. We were not able to say the same, unfortunately, about Bill C-11, the proposal to update the private sector law, PIPEDA. The bill died on the order paper when the election was called, and I hope the new parliament will present an opportunity to bring forward significant improvements. In my view, Parliament should follow the lead of Ontario and Quebec, which brought forward proposals towards responsible digital innovation within a legal framework that recognizes privacy as a fundamental human right. Quebec recently passed Bill 64, and Ontario is in the midst of serious consultations with the Ministry of Justice. about its own law. Canada's privacy regime has already fallen behind the privacy laws of many of its global trading partners, and now it's falling behind domestically as the provinces step in to fill gaps. This is not an abstract problem. The Council of Canadian Innovators considers a patchwork quilt approach to privacy in Canada as, quote, a recipe for disaster, unquote, and the, quote, worst possible outcome for innovation. It is normal in a federation to have different laws from one province to another, but there should be an effort to harmonize. And the federal government and parliament obviously have an important role in that regard. Along with the need for a rights-based framework, there is a need for common principles in both federal laws, the private sector law and the public sector law. For instance, necessity and proportionality have to be key factors in the decision to collect, use, and retain information. This is especially important given governments' increasing reliance on privately developed technology to carry out its business. As mentioned, necessity and proportionality principles mean organizations should only pursue privacy-invasive activities, for instance, facial recognition technology, which is extremely invasive, where it is demonstrated that they are necessary to achieve a pressing and substantial purpose, and where the intrusion is proportional to the benefits to be gained. Another key factor in federal law reform is interoperability. For both national security and business purposes, we need to be able to send and receive information across borders. The European Union's General Data Protection Regulation, or GDPR, sets high standards for protecting personal information. The EU will not freely share data with governments or companies whose own regulatory regimes don't adequately protect that information. Canada currently meets the adequacy requirement, but our status is reviewed every 4 years, and we're certainly not guaranteed a pass. As I've already said, domestic interoperability is also becoming a concern as Canada's largest provinces pass their own private sector privacy laws, which in some cases are better than the federal law. In conclusion, Canada aspires to regain its status as a global leader in privacy. We believe that Canadians deserve federal privacy laws based on rights. The incorporation of a rights-based framework in our privacy laws would help support responsible innovation and foster trust in government, giving people confidence to fully participate in the digital age. Adopting a rights-based approach would situate Canada as a leader on this file, showing the way by defining privacy laws that support the desired outcomes, protecting privacy, encouraging business development and innovation, and denying hostile states and other bad actors the targets of opportunity that can create national security threats. As a society, we must project our values into the laws that regulate the digital space. Our citizens expect nothing less from their public institutions. Strong privacy protection makes for a strong, resilient, and secure Canada. We should all work toward that goal. Thank you very much. I'll be glad to take questions at this point.
Thanks very much, Daniel, for an insightful set of remarks. I really appreciate it. And there's a couple of threads that you talked about that I do want to pick up on right away. So I'll ask you a few questions that I have prepared because it's not often I get to sit down with the Privacy Commissioner of Canada. So I've got a few that I want to ask. And then I've got questions coming in from the audience. So as I said, I promise to get to those. But I wanted to pick up on C11. So obviously, the government launched an effort to update Canada's privacy law. And the proposed changes sought to give Canadians more control over how companies handle their personal information online. But you argued the amended privacy protections would be, quote, a step back overall for privacy. So in your view, where did C11 fall short? And this is a two-part question. In what ways could it have done more to curtail this mass surveillance and the kind of behavioral manipulation that you were talking about in the tech industry that they're currently engaging in?
Let me start by saying that I agree with what certainly was an objective of Bill C-11, which was to provide greater flexibility for to use data for the public good or legitimate business interests. There are limits to the current consent model, and the law needs to be amended, in part to provide greater flexibility. But in order to achieve responsible innovation and build trust, this flexibility must come with three kinds of general parameters. One, it must be within a rights framework, as I've explained. Second, it must come with greater corporate accountability. Greater flexibility should come with greater corporate accountability. And third, the law should not be based on self-regulation, which I think was a feature of Bill C-11. The law should be based on objective and knowable standards adopted by elected officials and enforced by democratically appointed regulators, such as my office. If we start with point 3, self-regulation, C-11 gave companies too much flexibility to use information. For instance, by removing a previous requirement that consumers be able to know the consequences of the consent that companies seek from them. Also, companies would have been able to avoid consent if it was, quote, impractical, unquote, to obtain it. This is pretty close to self-regulation. C-11 also did not properly regulate the principle of accountability, which is an important counterbalance to increase flexibility. Accountability ultimately should be it should be able to be demonstrated to the regulator, an independent overseer of compliance with the law. With the complexity of technology currently and of business models, say in an AI context, in an artificial intelligence context, individuals are currently supposed to be filing complaints to the Office of the Privacy Commissioner to remedy problems that they have. But in that complex environment, individuals are not really well placed to identify these kinds of harms. That's why we think that companies, organizations, should have to demonstrate accountability to the privacy regulator, who should be able to do proactive inspections. In terms of the second part of your question, how do we avoid manipulation, for instance? This is where flexibility for businesses must be exercised within a rights-based law. Such a law, enforced by an independent and properly resourced regulator, would ensure practices that are inconsistent with human rights, first and foremost human dignity, like manipulation or discrimination, would no longer be tolerated. The regulator needs to have proper enforcement powers, so penalty provisions. And that was another flaw of Bill C-11, which provided for penalties for a very narrow band of violations. Most consent violations would not have resulted in penalties. Violation of the accountability principle would not have resulted in accountability. Notably, Clearview, that engaged in mass surveillance, in our view, would not have been subject to penalties under Bill C-11. So a number of flaws, although we agree with, I think, with the objective of giving more flexibility, but within legal parameters that ensure the respect for rights and that would provide trust to consumers.
Absolutely. No, thank you. And you were very diplomatic when you said limits on the consent model. I've argued that we've constructed an entire artifice on a lie. I couldn't tell you if I've met anybody who's ever read all the terms and conditions that they've agreed to and consented to, but nevertheless, I digress. I wanted to come back to Clearview AI. And so you talked about the billions of images being scraped, the facial recognition technology being deployed. And realistically, I mean, it's deployed in a patchwork of statutes statutes and case law that doesn't specifically address the risk posed by that technology. So my question to you, sir, is this: can facial recognition technology be used in a manner that protects individuals' privacy rights? And if so, what are the accountability measures, enforcement powers, and oversight mechanisms needed?
Like all technologies, facial recognition is neither good or bad on its face, although this particular technology is extremely invasive in that it is easy to use. You can take a picture and then apply facial recognition to events that occur in the public, and it relies on information of a permanent nature. So this is a technology that can provide benefits, for instance, in the investigation of serious crimes or to find missing persons, including children, but it has particularly high risks because of the invasiveness of the technology. The law indeed is not particularly well tailored to that technology. There are general principles that apply, charter principles, some general principles under privacy law, under criminal law, but it is a patchwork of principles that are at a very high level of generality. In an effort to try to provide some more specific guidance, my office, along with provincial and territorial privacy commissioners, published draft guidance in June, and we're currently consulting with stakeholders on that draft guidance. We want to provide assistance so that this technology is used responsibly, and we want our guidance to be grounded in reality of the practice of police forces. And that guidance, I'll just go through a list of principles, promotes the following principles. One, lawful authority, obviously. Again, necessity and proportionality, meaning in the case of facial recognition that it should only be used for specific purposes, not for investigations writ large. Privacy by design should be applied. That's why I'm glad that the RCMP, after frankly having allowed its line officers to use technology without much monitoring, is establishing currently mechanisms to oversee the use of novel technologies, not with a view to prevent their use, but with a view to ensure that these new technologies are used responsibly and lawfully. Another principle that's worth mentioning for facial recognition is accuracy. So this is a technology that is becoming more and more accurate, but it is not fully accurate. And we know that this has led to problems like discrimination, for instance. And accountability and transparency are also important. So all of these principles are important. Ultimately, or at the end of this exercise, one question that I think is worth considering is, are there uses of facial recognition because of its extreme invasiveness that should be outright prohibited? We know that some US cities, for instance, have banned facial recognition completely in the case of law enforcement. In Europe, the European Commission has not gone so far as to propose a complete ban for facial recognition, but it has tabled a draft regulation that seriously sets parameters for the use of facial recognition, including limiting its use for investigations pertaining to very serious crimes or searches for missing children. And also, relevant to your question, Aaron, about manipulation, the draft EU regulation suggests a no-go zone for using technology subliminally to manipulate an individual's behavior in a way that is likely to cause physical or psychological harm. So that's quite broad, but it raises interesting questions as to, in Canada, yes, facial recognition should be used because it has great potential in some investigations. But are there situations where it should be prohibited?
Thank you. And it strikes me like the underlying kind of current of your remarks are that the more powerful the technology and the more significant the implications of its deployment, the more rigorous we need to be along those principles. And in particular, the one about accuracy stuck with me. I read a paper yesterday. There was a diagram in there called Chihuahua versus Blueberry, and the facial recognition being deployed couldn't distinguish between a Chihuahua and a blueberry muffin. So there are errors, and accuracies very important if there's going to be profound implications as a consequence of that deployment. I wanted to come back to this idea of the memorandum of understanding that your office signed with NISRA, or sorry, for those members of our audience that are not deeply steeped in national security law, the National Security Intelligence Review Agency. So your office signed a memorandum of understanding with the NISRA. I just have one simple question. Why is this an important step for your office?
At the level of principles, it's important for oversight bodies to work together, to have the authority to work together. Until a few years ago, we did not have the authority to work together with CIRC, for instance, the predecessor to NZERA. It's important that we work together in part to be more efficient, to avoid duplication of efforts, as the current law says. But I think very importantly, because we come at these reviews, NZERA and my office, with complementary but different expertise. They're experts in national security law, we're experts in privacy. And to be able to put together the respective expertise of these two kinds of oversight bodies is extremely important so that the reviews that we conduct benefit from the expertise of the two bodies, and therefore that adds a lot of value in my perspective. We reached the agreement to declare publicly that we're working together. We declare publicly our objectives, and we think it's extremely important to be transparent in part to the public, but in part to departments and national security agencies to know that we're working together and what our common objectives are.
Thank you. And I promised to take as many questions as we could from the floor, so I do want to make good on that promise. So the first question coming in from the audience, and I'll just warn you, Commissioner, that this could be the subject of a PhD dissertation, but I'm going to ask the question exactly as written. The Federal Privacy Act is very dated. What, in your view, could be changed to make government services more useful and available online while strengthening our privacy rights?
As I said in my remarks, we're quite optimistic about the content of the discussion paper produced by the Department of Justice on potential amendments to the Public Sector Act, the Privacy Act. That law is about 40 years old, so information then was collected, as you can imagine, in vastly different ways than currently. And the fact that technology makes the collection and disclosure of information easier, yes, as the question suggests, is promising in terms of the quality of services to the population that comes from sharing information among government institutions. But it does create a totally different environment. At the time in the 80s, information was on paper form, in filing cabinets, and importantly, legally, there were silos that is certainly in the view of a number of government departments, if not most, are an impediment to better decision-making, but there were advantages to silos from a privacy perspective. We're no longer in that world, and I'm not recommending that silos be maintained as they were. So I'm fine with the fact that there would be greater information sharing between departments in order to advance the public interest, in order to improve public services. But the protection that legal silos and paper records provided in the 80s needs to be replaced by some other protection. Otherwise, privacy is no longer protected. And I think the best protection in that environment is a law that recognizes privacy as a human right. So that provides a filter for what is appropriate in terms of collection and sharing of information. And as for the private sector, it's important that the public sector law give the Office of the Privacy Commissioner meaningful enforcement powers. And that appears to be, in large part, what the DOJ discussion paper proposes. So in part, new legal parameters that replace the older protections, and a regulator with some powers to ensure that the rules are indeed respected.
So the next question coming in actually dovetails perfectly with that, because it is about that statutory right. So would you agree that a clear statutory right to privacy shaped to regulate all social media, telecom, and other licensed utilities would strengthen protections for privacy for all Canadians?
A single privacy right meeting for across sectors, the public and private sectors, I assume. Absolutely. Information knows no borders, geographic borders, but also borders as between the public sector and the private sector. And increasingly, as we know, the public sector relies on public sector technology and expertise to manage information, or at least to assist in decision-making. We've seen that with contact tracing application, for example. There are many, many examples of that. So because personal information needs to be protected regardless of the context, regardless of whether it's public sector or private sector, I think it's important, it's extremely important, that the legal principles, including the right to privacy, be defined, if not in the same way, at least in a very similar way, that there be common legal principles that protect privacy both for the public sector and the private sector.
Thank you. And we've been talking a lot about privacy almost independently, but as you appreciate more than most, there's a dynamic interplay across a range of policy areas. So our next question coming in says, could you please comment on the intersection of privacy and competition?
Yes. So that's an issue that is coming more and more to the fore. We've always had some level of cooperation with the Competition Bureau federally in Canada, for instance, but we cannot, for one thing, share confidential information that we collect during our investigations, to have the kind of cooperation and adding expertise as we can currently with the National Security Review Agency. So that's unfortunate, but clearly there's a link. We should be able to work more closely with the Competition Bureau. We do exchange at some level of generality from a policy perspective. Both laws at some level seek to protect consumers. So there's congruence between competition law and privacy law to that extent. There may also be areas where privacy and competition may be in somewhat of a tension. So this is a nascent area, which is very important for the protection of individuals as consumers. We know that we want to work with the Competition Bureau, and that internationally this interplay is becoming more and more important. But I'll say it's a bit tricky, and we need to think through with some rigor, when do the two laws converge, and when do they potentially create tensions between one another.
It's a good point. I wish there was a think tank that was working on that. He says in jest, obviously, we're going to be taking that issue up at CIGI, so we can be in touch later about that. Another question coming in from the floor. Canada has data privacy exposure in the startup space. As founders get their businesses off the ground, sometimes cybersecurity and other issues like intellectual property are not the focus until later in the scaling process. What is your message to founders and early stage companies about the role of data privacy in their scale-up strategy?
I think in a world without borders, if a Canadian company is scaling up, clearly it has to know that it has to operate with governance principles that are consistent with laws of a number of jurisdictions, whether the US or the EU being important case in points. So I think data privacy for a company, particularly a scale-up company, should be seen as a sine qua non for the eventual growth of the company, and therefore in devising the business model and the rules of engagement of a company, it's important to think about these things as early as possible. I mean, that's an example of privacy by design, a Canadian made concept that was promoted first by Anne Kurukin. So it's important to think about these things early on.
Absolutely. It's a great recommendation. This question goes to the online harms regime. So the question comes in and says, what concerns, if any, do you have about the proposed online harms regime and the new data commissioner/tribunal that is expected to be tabled in the coming parliament?
I think I'll reserve my comments for Parliament. We expect a bill, and our policy is to try to respect Parliament in these situations. Well, you'll have to stay tuned.
No problem, and that's very fair. Okay, we have another one coming in. Could you describe your current and desired auditing and order-making power over private companies?
Yes. So as I was explaining in my remarks, as we all know, technology is complex. We're no longer in the world of bilateral relationship between consumer and company. There is still some of that, but it's not where most of the action is. So data is used for several purposes. And it's normal, and that's how there can be value from the data, from personal data and other data. The complexity of technology and the complexity, if not opaqueness, of business models means that the complaint-driven system that we have today will not be a good system to protect consumers who more often than not will not understand the harms that they're exposed to other than very superficially. So that's why there needs to be somebody with independence from businesses and government who knows a little bit about certainly technology and privacy law, a little bit about business models, to be able to, quote, look under the hood, as we say sometimes. Now, that can perhaps seem threatening to some organizations. Our role at the OPC, were we to have this proactive auditing power that I'm seeking, and I hope that we will have in a new law under a new parliament, we still maintain that our role is first and foremost to assist regulated entities, whether they be private or public, to comply with the law. So we want to help, and we have advisory services to that effect. But sometimes we need to look under the hood on a risk basis. If we have that authority, we will not use it willy-nilly, and resources will be a constraint. So we will have to be judicious as to when and where we will audit proactively so that it honors practices that we think are likely to cause harm to a large segment of the population.
Thank you. We only have 1 minute left, but I'll try and squeeze in one last question. And this is about Canadian courts and digital evidence. How vulnerable are Canadian courts given evidence and documentation is now submitted electronically? Is there oversight or legislative or privacy regulation needed in this area? So kind of it goes to the heart of digital evidence in courts.
I think I'll pass on this one.
Fair enough. And actually,
I haven't thought this through.
It worked out well because we only had a minute, so all good. We'll take the pass. Well, thank you so much, Daniel, for this fascinating conversation. I mean, we really appreciated your thoughtful analysis and the comments that you made. I hope that you, the audience members, enjoyed this event. If you would like to watch it again or share it with your colleagues, we will be posting it on CIGI's YouTube channel shortly. Please feel free to subscribe to CIGI Online on Twitter, Facebook, or LinkedIn to keep up to date on our upcoming events and publications. And as I sit here reflecting on the conversation that the Privacy Commissioner and I have just had, I'm struck by one thing. Oftentimes you hear that there's a tension between privacy and national security. As I reflect on the conversation, I'm heartened by the fact that there's actually mutually reinforcing objectives. A strong privacy regime and a strong privacy commissioner in Canada will only benefit national security. It will increase public buy-in and will allow our agencies to do what they need to do in the 21st century. So thanks again to the Commissioner for this insightful set of remarks. Thank you to our audience for joining us. Have a great day, and most of all, stay safe.